All right. Well, that's the judgment at the Constitutional Court. The judgment handed down there by Justice Busisiwe Mkhwebane. And that judgment, not just a judgment on the public protector and what she sought to do, which was to appeal an earlier High Court ruling, which that appeal, as I understand it, listening to the Constitutional Court judge there, the court saying, he said earlier that the court had dismissed the public protector's appeal, but there were other appeals as well that she sought. For example, the personal cost order appeal, that it would appear that the public protector did succeed. It would appear. I still need to gain clarity myself, because the legalese or the legal language can be very confusing at times if you're not a lawyer. And there are several other matters, but this judgment, very, very scathing, I should say, on the conduct of the High Court as well, in as far as the issuing of personal cost orders. The Constitutional Court Judge then, Busisiwe Mkhwebane, talking about 4 matters that have come before that court on the public protector, and each of these had the issue of personal cost orders, and the judge expressing himself there that this is not the way to go. If that office is to continue working, these personal cost orders have a chilling effect on the work of that particular office, stating very clearly that the office of the public protector is more important than the incumbent. I have with me in studio my colleague, Tumaole Mohlaoli. Tumaole, let's first deal with the appeal. What was your sense about what the judgment is? By the way, it is a unanimous judgment, I might add.
Yes, a unanimous judgment at that, Goli. So my sense on the judgment, based on what the justice has said, is that when it comes to the appeal, talking about the powers of the public protector to subpoena records from the receiver, with that appeal basically having been dismissed and set aside, it just basically means that the public protector does not have the scope to subpoena the receiver of revenue, because the receiver of revenue, in terms of the law that guides the protection of an individual's rights and individual's information, which is deemed sensitive, which is kept by the receiver of revenue. The justice going there saying that that supersedes any subpoena that she might perhaps have and see as a tool that she could use to override the law that governs the protection of the individual's personal.
On that very point, Tumaole, you're quite spot on, because this has to do with the section 69(1) of the Tax Administration Act, and it would appear that the public protector sought to sidestep this law, and the court is very clear that she could not do that.
Yes.
Although he also does say, though, that there are reasonable prospects for success. He says that there are strong prospects of success, I guess, if the public protector goes about this the right way.
Yes.
Instead of what he said were her power testing expedition that she went on in order, basically saying that also she ventured into unknown territory.
Yes.
I thought that was very scathing in the manner in which the public protector went about this.
Yes, in the manner in which she went about this. So this judgment basically just curtailing the methods that were used, saying that the public protector should have known better, should have known that indeed if she had felt that these particular records were critical to any investigation that she was doing and were key to any of the findings that she would have made, that there are various channels that she should have followed, not could have, but should have followed, and that in basically ignoring those channels, she was basically going on a venture of her own and trying to try her luck, so to speak, and that would not send the correct message, and in fact she should have known better. When an office of her stature should be seen to be following processes that are fair and processes that are there and overseen by the law.
Even though the judgment itself does say that the person in question whose tax records were being sought by the public protector, that's former President Zuma, he was willing to consent.
Absolutely.
Take us back there. What was this about in the first place that the public protector wanted these records?
Well, what she wanted these records were, Koli, basically it stems from payments that were made or allegedly made to the former president by a businessman, 1 million rand. And this businessman is politically connected, Roy Moodley. This 1 million rand was in the first few months of the first term of former President Jacob Zuma's tenure as head of state. And so what the public protector is seeking to investigate is that a complaint was laid about these particular payments, in that the allegation was made that these payments was for Moodley and his company to curry favor with the president, the then president, and therefore receive contracts and receive business. So this is exactly what's at heart of these particular records, what the public protector was seeking to find out from the receiver of revenue and to get how these payments would have been made and whether these payments actually existed. And this, it speaks to the heart of that complaint that she's investigating.
Now, let's move to the other element of this appeal by the public protector. And there was, according to the receiver of revenue, the commissioner now, Edward Kisweta,
yes.
There was a failure to invite him on this matter so that he is aware of what is going on. And so it would appear that the public protector, in the High Court judgment, she may have been seen as a person who acted in bad faith, but the Constitutional Court does not see it in the same way.
Which is very interesting because...
And this is where the High Court comes in for the hammering.
Yes, this is where the High Court comes in for the hammering, because on the issue of acting in bad faith, the commissioner of the receiver would have wanted to be in on all aspects of the matter and would have wanted to be given access to all the information in terms of the court processes. However, when you listen to the Constitutional Court's ruling, it seems that this was not necessarily necessary, that SARS would then have to be given that blow-by-blow details of what is happening in a process that it is a respondent to, that it would have to participate in that particular aspect as an observer and see what the courts have to say, not necessarily being invited to be part of the process, which would suggest that it is, both the referee and the player in the game. So the Constitutional Court saying that in that respect, SARS would not necessarily have had the inside edge and have been invited to every deliberation, so to speak.
Yeah, and then there is this term that the Constitutional Court Justice Busisiwe Mkhwebane says was the, I guess, part of the text of the High Court judgment, that the public protector's proclivity to operate outside the law. And then he goes further to explain the dictionary explanation of what the word proclivity means. And he says that this is a tendency to do something regularly. And the Constitutional Court Justice saying it beggars belief as to why the High Court would use such language, when in actual fact they were in a way trying to hold the public protector on such high a standard that, and I quote, this standard legally it was, or it would have been non-existent in the first place.
Absolutely. And
the High Court, what's going on here? Are they looking at these matters through the incumbent in the office, or is it the office still that has got to be answerable here? I don't know. I don't know what exactly the...
What it suggests, Koli, when you listen to it, it suggests that the Constitutional Court is concerned that the lower courts, particularly in this matter, seem to be attaching the office of the public protector to the individual in this particular case, and that some of the judgments would certainly suggest and paint a picture of the Public Protector's Office in a very negative light when you use the language that's been passed down in the judgments, and that would then, as he had already mentioned, create a situation whereby anyone who seeks to then come and
occupy
the office would then think twice or think thrice about what this would mean for them in terms of the public opinion.
Exactly. And this is where the judge talks about how this whole issue around the personal cost orders, which is the next subject matter I want us to deal with.
Yes.
If these continue, the personal cost orders, they are likely to send a chilling effect on the work of the public protector. And this is where the Constitutional Court justices say that the office, it's got to be remembered by the high courts when they issue these judgments, that the office of the public protector is more important than the incumbent.
Yes. Because what then these orders would suggest is that the incumbent would then be liable for costs in a matter, personally liable for costs in a matter where the office is also a respondent, obviously by virtue of the incumbent being at the helm of the office. But yet, when you have the incumbent then having to deal with personal costs, what appetite would then the incumbent
any individual want to occupy that office?
Yes, to accept being to assent to that office, if I can use that term, or to take on matters, at the risk of losing in a court of law, knowing that the bottom line would come from your personal pocket. I mean, this would be something that would be enough to deter anyone speaking, not from a legal point of view. When you're looking at it, or in these tough economic times and going forward, certainly one would think twice about taking any matter. But then that also hamstrings the public out there when individuals feel that they have a matter where they need the Public Protector's Office to stand for them, knowing that perhaps they would receive a very lukewarm reception when one thinks as an incumbent that, I'm going to get, struck hard in the pocket if I lose this matter. Then it doesn't, create confidence when someone approaches the office of the Public Protector, knowing that all these variables are at play. So certainly something a lot to think about when it comes to these judgments and how the Constitutional Court is looking at the importance and the role that the Office of the Public Protector occupies and the great work that it's meant to do to protect and to also stand for those, to champion the rights of those who feel that they don't have a voice.
Yeah, and perhaps the best way to end it here, Tumaole, is what the Constitutional Court Justice who was handing down this judgment, Busisiwe Mkhwebane, was saying, that the Public Protector is not fair game for personal cost orders.
Yes.
Yeah. Now that is a strong message. Very, very interesting turn of events, if I could put it that way. The judgment that has just been handed down, yes, scathing on how the Public Protector went about this case, but also just as equally scathing on the High Court that issued the initial judgment on this matter. Constitutional Court itself, by the way, they're reminding themselves that out of the 4 matters that have come before them involving the Public Protector, where they sought a personal cost order against the Public Protector, 1 did succeed in as far as the issue of the personal cost order. So very interesting indeed that judges themselves are now judging themselves about how they go about handling matters coming out of the Public Protector's Office. Well, in a moment, we're going to talk to Karinda Jagmohan. She's our reporter live in Durban. There she is, and she is following matters around the newly announced COVID-19 restrictions and reactions from members of the public as we are in festive season. How are people not going to go to the beach? But we'll have more information from Karinda Jagmohan in just a moment. This is Newsfeed, the AM edition.